Welcome, everyone. We're going to do a super fun workshop today on con law, but just to warm ourselves up, I'm going to finish the con law questionnaire. So if everyone can see my screen, we started with some really important concepts of con law to jog our memory, like standing, political doctrine, mootness and ripeness, specific powers of the different branches, which will make us think about separation of powers and usurpation. We have the Commerce Clause and the Dormant Commerce Clause. It's going to be a common answer we'll see today. Commerce Clause allows the federal government to regulate the channels, instrumentalities, and economic activities that in an aggregate have a substantial effect on interstate commerce. And the Dormant Commerce Clause prohibits states from enacting legislation that directly discriminates or unduly burdens interstate commerce. Now, one answer that we may see today is that states can, in fact, enact legislation that would otherwise burden interstate commerce if it's explicitly authorized by Congress. Look for that answer and consider that. Remember the whole scenario. It's like the Russian dolls. Sorry. The federal government is the big boss, and they make the rules. The states are sovereignties that are, in this metaphor of the Russian dolls, within the parameters of the federal government. So if the big boss federal government tells the state government they're allowed to do something that they otherwise wouldn't be allowed to do, it's kind of like, the principal telling the kid that they could, skip class even though that the teacher wouldn't let them. Like the principal is the big boss there who's giving them express authority to enact legislation that would otherwise violate the Dormant Commerce Clause. So just remember that whole concept of preemption and state police powers. States operate as sovereignties, but under the overall guidance of the federal government. Another way that is tested is the states cannot directly tax federal activities. So if the federal government is running, a train through the state can't say, oh, we're going to say that you can't run trains through our state. Like the federal government can have authority over the states. The states are allowed to enact legislation that does not directly conflict with the federal government. Also makes you think of the commandeering, anti-commandeering clause, where the federal governments cannot force states to enact legislation, but they can influence them, usually by conditioning on funding. Classic example is, so we want to have a law about how old you have to be to buy alcohol. And if you don't conform with this law, then we will not provide funding for your highways. That's a way of influencing the states to act, but not commandeering. So we talked about some other really important things here. I talked about incorporation, how we incorporated the Constitution to the states. The 14th Amendment was huge for incorporating due process to the states. Eminent domain is the taking. Think about the difference between a physical taking, they take the property, or a regulatory taking, which is they enact a law that renders your property economically useless, or it deprives you of your investment-backed expectations. You expected to grow corn on the property. Now they made a law saying growing corn is illegal. Well, they pretty much rendered your property useless. That would be an economic taking. Speech and debate clause we talked about. People, legislators, and their aides are not going to be in trouble for, civilly liable for defamation, let's say, within the course of debate. Very important. I'm going to read this again because it's going to come up on our workshop today. Very important. Well, before I get to that, very important, let me talk about two things quickly. Full faith and credit clause is an answer that you will choose, definitely on test day. Look for one state given the option to recognize or refuse to recognize the judgment of another state. They will have to recognize it under full faith and credit clause. And then the 5 guarantees of the First Amendment. One you can always remember is Dave Chappelle's famous skit, I plead the fifth, the 1, 2, 3, 4, 5, all the things I can plead, I plead the fifth, right? And then he pulls up a piece of paper that says fifth, F-I-F. If you haven't seen that skit, it's super funny, but it's about your right against self-incrimination. Fifth Amendment also has due process. which is procedural, your right to notice and hearing, and then substantive, which is people's rights not to be deprived of their life, liberty, and property. Again, with property, that brings up the third thing on the Fifth Amendment, which is a takings clause. And I just talked about physical taking versus regulatory taking. A per se taking would be like if they put a sign in your property. They haven't taken your property, but they've deprived you from being able to use that 6-inch by 6-inch spot in your grass. So we have due process, we have the takings clause, we have your right against self-incrimination, and then we think of some criminal aspects of the Fifth Amendment, which would be your right against double jeopardy and your Miranda rights, your rights to counsel before adversarial proceedings have begun. But now let's talk about this very, very, very important subject. You need to know these words exactly. And Daniela came up with a mnemonic for it. I can't remember it, but maybe but next week I'll have it down. I'll be able to teach it. But let's just go word for word. Rational basis. The burden is on the challenger, the plaintiff, to show that the state action is not reasonably related to a legitimate state interest. Intermediate scrutiny. The burden is on the government to show that the state action is necessary to achieve an important government interest. And in strict scrutiny, the burden is on the government to show that the state action is narrowly tailored to serve a compelling government interest. So rational basis. And when you're picking these answers, it has to be correct. Like you might think, oh, this should be rational basis. But if they say, it's the burden is on the government to prove it's reasonably related, that wouldn't make any sense. Your answer choice has to at first be correct and then be the right answer. It has to be accurate of a statement and be the accurate answer. So rational basis burdens on the challenger and it has to be reasonably related. Intermediate scrutiny burdens on the government and has to be necessary to achieve an important government interest. There we're thinking gender. But remember, with gender, it has to be targeting the gender. It can't be an effect of it, right? If we say public schools, all students have to wear shorts below their knees, that might affect women more than men, but it's not targeting women. So it wouldn't be appropriate to have intermediate scrutiny for that. But if there was a law that said all women have to wear shorts below their knees, well, that would certainly bring up the concept of intermediate scrutiny. Intermediate scrutiny could also apply to illegitimacy, the right to recognize a child. So strict scrutiny would be, again, burdens on the government and has to be narrowly tailored to serve a compelling interest. Race, alienage, and national origin. That random mnemonic is fire. Camper, contraceptives, marriage, procreation, education, raising your children. Fifth Amendment, First Amendment, right to vote, right to travel, access to court, Second Amendment. Some states recognize the right to work as a fundamental right. Anyone think of any other fundamental rights?
There's right to privacy. I know that.
Expressly in certain states. In the state of Florida, right to privacy is a fundamental, expressly stated right. Federal Constitution, it's a little more implicit, but I would lean towards saying that right to privacy is a fundamental right. This one we talked about a little bit, rational basis with bite. Just know that this applies mostly to sexual orientation, right? Your who you choose to romantically associate with, and it's a little bit heightened of a stance than rational basis. So I don't know if we'll see any practice questions with that because it's kind of a newer concept, but they are at liberty to test the law as it is today. So that is a statement. If you see that statement on the test, rational basis with bite, at least you heard it from me. Okay.
Andrew, actually, I do have a question for that particular idea. Like, I know with the different levels of scrutiny, there's like certain words that define the levels of scrutiny. So what would like a rational...
There's no specific word that will define rational basis with bite. It's just going to be an understanding that based on historical precepts and implications that just mere rational scrutiny is not considered enough and they have to take a heightened look at it. That's a good question, but there's no magical buzzword for that. The magical buzzword is rational basis with bite. Okay, so symbols and conduct can be speech, and this is under the Spence test, where these symbols or conduct meant to be speech, and would the public recognized as speech, such as flag burning, right? Flag burning could be recognized as speech, but there's a question where there's an ordinance that says no burning of objects in the building. That is not regulating speech based on content, so that ordinance would be constitutional, but regulating flag burning as speech would be subject to strict scrutiny. So what are the differences between content-based and content-neutral? Content-based, strict scrutiny. Content-neutral is going to be intermediate, time, place, and manner, which regulates the forum, but not the content. It's heightened intermediate scrutiny. Here's another example of heightened intermediate scrutiny, because there must be an alternative means of communication, and it regulates how speech is expressed, but not what speech. So we talk about different forums, and I sent a very lengthy article in the Telegram chat about the forums, very difficult concept, and it's ambiguous at best, but a public forum is ruled by the Supreme Court to be courthouse, park, sidewalk, streets. Private non-public forums, private prison, a business, a military base, the inside of a teacher's mailbox, the office of a governmental employee, and then private forums designated for public use would be like a private college hosting a public gathering. Very, very tough concept. And if it's a limited use public forum, it only needs to be viewpoint neutral, not content neutral, which difficult subject. And I have some sophisticated reading that might help clarify that. What types of location has the Supreme Court found to be private forums? Prisons, military bases, airports, schools, and libraries. As Matt Beckerman taught, the best way of approaching it is just to kind of memorize the examples of public forums: courthouse, parks, sidewalk, streets, versus private forums: prisons, military bases, airports, schools, and libraries. Now, school, it can be public forum in certain aspects, and public schools do have to conform with constitutional implications if the state is involved with the activity. So what categories of speech are not protected in the First Amendment? Criminal threats, hate speech, fighting words, words likely to incite imminent loss activity, obscenity, defamation, false or misleading commercial speech. What makes speech obscene? If it appeals to the prurient interests of human nature. Be careful that it doesn't have any social, cultural, scientific, artistic merit. One thing just to remember about time, place, and manner, it's very important to remember same clown, different wig idea, pattern recognition. They are allowed to say in the town of Ybor City that all the strip clubs have to be in one location. That's a time, place, and manner restriction under the law. And again, does that clearly sound like a time, place, and manner restriction? Maybe, maybe not, but it has been clearly defined as a time, place, and manner restriction. It's not saying that they can't do it. It's just saying where they can do it. And it does give them an alternative means of communication all within the one neighborhood. Okay. When is commercial speech protected? If it's not false and misleading. So false and misleading commercial speech is not protected. We need to show actual malice for a public figure for defamation, just mere negligence for a private figure. Prior restraints, so like gag orders, almost never allowed. So we couldn't have a law that says no one is allowed to speak about the upcoming presidential election for 1 week, right? That would be struck down as a prior restraint. What speech rights do public school students have versus government employees? So you do not have a right to wear bong rips for Jesus shirt in public school because it arguably affects the learning process. Government employees, government compelled speech is allowed. Government official can speak on public interest as a private person, but not if it negatively affects his public post. There's a good question about the mayor here, and he can't be fired just for saying something. But if he says something to the effect of like, you know, I would never do my jobs for that guy, then maybe he could be punished.
Andrew, I think
Sure.
I was trying to get into this class.
Oh, all right. Good luck. Thank you.
Yeah, no problem. And I actually got that question yesterday when I was doing practice questions.
Nice.
Yeah.
Okay. What's the significance of the Employment Division v. Smith? A law that's applied neutrally isn't a First Amendment violation if it's applied in a non-discriminatory manner. Example of this. Two very, very compelling examples. And again, the line is gray. I wish Matt Beckerman wasn't on the train because he can help us. But to my understanding, I can explain to the best of my ability. There was a case in the West Coast about peyote, and they said they cannot use peyote. one native tribe said, well, we use peyote all the time in our practices. And they said, too bad. This is a generally applied law. We're not targeting your religion. We're just saying you can't use peyote. For those of you who don't know, peyote is like a cactus-based drug, from what I gather. But that law was deemed to be constitutional because it was not targeting that group. Now, here on the East Coast in Miami, they had a law that said you cannot sacrifice goats. Well, enough facts around the situation made it evident that that law was actually targeting the Santeria voodoo religion. And they decided that because it was targeting that religion, that law was unconstitutional. You're all law school graduates. Give yourselves credit. You're very, very smart people. You're part of the 1% of people who graduated law school. Very, very smart people. I would listen to you all argue either way on that scenario, which one was targeting, which one wasn't. It really had to do with the facts. And I think in Miami, a lot of people wrote in the newspaper, like, this is just targeting us. This is just targeting us. And evidence came out that indeed it was. All right. So freedom of assembly, a petition of the press. Assembly cannot be punished for belonging to a group. Petition is freedom to protest. And then press, any laws that affect newspapers are subject to strict scrutiny. What does vagueness and overbreadth mean? Definitely look for these answers, and we'll hopefully see some today. Can you have a law that is only vague but not overbroad and vice versa? So vagueness, it's not clear what behavior is being punished, and overbroad also punishes legal behavior such as speech. Yes, of course you can have laws that are one or the other. Why not? So loitering is a good example of vagueness. What does loitering mean? A lot of jurisdictions say that loitering is a vague law. I can't stand out here with my hands in my pockets. You know, like, what does loitering even mean? Overbroad, it punishes too much than it's intended. The example I give is silly, but it helps verify it. What if they had a law that public school teachers cannot say 4-letter words? I'm sure you know what we're targeting there, but that would also preclude them from saying door or mark, right? Because those are 4-letter words that are legal to say or not within the parameters of the legislation, but it would be overbroad to just say 4-letter words. A better piece of legislation would say public school teachers cannot say words that have been deemed by Webster's dictionary to be curse words, offensive words, violent hates. You know what I mean? Like, it would have to be very specific to not be vague, and it would have to be not overbroad so that it wasn't also punishing legal speech. Again, you could still come up with a lot of reasons why that piece of legislation might not be constitutional, but I'm just saying the overbroad and vagueness illustrations hopefully resonate. So procedural due process, notice and hearing, what's the government interest, and what is the risk of deprivation to the individual? We think of due process a lot with, if you're a professor at a public school with tenure and they're trying to fire you, you need notice and hearing for that to occur. What's the difference between substantive due process and equal protection? Substantive process is when the law discriminates against everyone. Deprivation of life, liberty, and property. Equal protection is when a law discriminates against a certain group of people. Important. Due process against everyone. Equal protection, certain group of people. There has been incorporation and reverse incorporation, so due process does apply to the states via the 14th, and equal protection does apply to the federal government via the 5th. So suspect classes, race, aliens, national origin. What rights have been found under substantive due process, under equal protection? Do you think there's a difference between rights found in each clause? So some examples I made, I think, last year with Matt were substantive due process. If the government said all people have to wear a mask, that's arguably a deprivation of substantive due process. Arguably is the keyword. What if they said all men have to wear a mask, or all people of a certain religion have to wear a mask? Then that would be equal protection. If they're targeting equal protection, if it's just a deprivation of rights, it's going to be substantive due process. So I think these questionnaires that we have for every subject are very valuable. Does anyone think the same? All right, so I'm going to just jump right into the workshop, and we're going to do live questions, if that sounds fun for everyone. I was supposed to show you all my little business presentation. We don't have enough time to do that, but let me just see how, just so you know, this is my business. It's not just bar prep that I do. I have an amazing team. If you've never seen your customer service representative, like how smiley they are. Alexis, Jesse, James, and Sam. I have a support staff. We have up to 100 tutors right now, including Robert and Amy, who are bar tutors. We have tons of departments. You can see the bar exam is just one of our many departments. I'm the owner of the entire business, but I focus a lot of my attention right now on the development of our bar prep business. And our slogan is one student at a time, revolutionizing education. So I believe in that. I want everyone here to pass this test and help us change education. We're available nationwide. We do virtual, live group classes, digital materials, self-paced classes. And as you all know, I'm writing a book for the Florida Bar specifically. Top tier testimonials. They say we are the best live course, not me, but they. This is our family. You can see there's even a member of the class here when she took her LSAT, and one of my previous, five of my previous bar students, and 6 of my previous bar students. Now I think about it, we really go hard for the bar, but we also do childhood education. Education super important. Education is a super cool industry. We did just come up with a mobile app. If you go to the App Store and download the Ibis Prep app, and education is the passport to the future. For tomorrow belongs to those who prepare for today. So that was my commercial. You know, there's commercials in life. All right, now let us go to the workshop. And what I'm going to do is admit my boy Jackson Manuel, absolutely. And then I'm going to pull up the polls quizzes. This should be our last MBE class on my, oh, I'm not here. You haven't been able to see me? This should be our last, why can't I, sorry. This should be our last class on my iPad. I treated myself over the holidays to a laptop, so I'll be level playing field, and I think it is better a visual on the laptop. So thank you all for bearing with me. Can we all see the poll? Is it up? All right.
Yes.
I have to stop screen share real quick. Oh no, cool. I could sign my fingerprint. All right, let's get it. So, you know, we might go a little bit over. I hope to do at least 20 questions today, but nothing too crazy. I did think it was valuable to go back over that questionnaire because I'm a man of my word, and I said we were going to do it, so I had to do it. So you see my percentage so far on my little adaptive art is 100%. So I'm counting on y'all today. I told you common law is not my favorite subject, but if we get some wrong, life goes on. All right, let's see if we can do 20. We'll move a little bit faster pace today than normal. And if I press this magical button right here, that'll give us an opportunity. I'm gonna read it out loud. Can you all see the poll?
Yes.
And you can see the question?
Yes.
Yes.
Okay, life is good. Oh, life is good. All right, an ordinance of a particular city. Honestly, I'm going to read the call to question because it's a little bit longer. The chairman responds by joining the candidate and requesting the court to declare the city's residence requirement invalid. In this case, the court should blank. So we're talking about the residence requirement and declaring it invalid or not. An ordinance of a particular city requires that its mayor have continuously been a resident of a city for at least 5 years at the time he or she takes office. A candidate who is thinking about running for mayor in an election that will take place next year will have been a resident of the city for only 4.5 years at the time the mayor elected then takes office. Before he decides whether to run for position of mayor, the candidate wants to know whether he could lawfully assume the position if he were elected. As a result, the candidate files suit in the local federal district court for declaratory judgment that the city's 5-year residence requirement is unconstitutional and that he's entitled to a place on his political party's primary election ballot for mayor. He names the chairman of his political party as the sole defendant, but does not join any election official. The chairman responds by joining the candidate and requesting the court to declare the city's residence requirement invalid. In this case, the court should refuse to determine the merits of the suit because there's no case or controversy, refuse to issue a declaratory judgment because an issue of this kind involving only a local election does not present a substantial federal constitutional question, issue the declaratory judgment because a residency requirement of this type is a denial of the equal protection of the laws. Issue the declaratory judgment because the candidate will have substantially complied with the residency requirement.
Andrew, can you scroll down a bit so we can see D, please?
Oh, my bad. Yeah.
Thank
Por
you.
supuesto. Does anyone need more time? So if I look at this poll, wow, everyone answered. Oh, no, yes, not everyone. Sorry, my bad. If y'all didn't get to answer that one, don't worry. There's a confliction here, but mostly people are picking A. Does anyone confidently have a reason why they would pick A in this answer?
It says that the candidate was thinking about running for mayor. He didn't run yet.
Mm-hmm. Anyone
And
else
so
have
as
any?
a result of that, there's no claim to make because he hasn't been affected by it yet.
Anyone else have any thoughts? It's a good point. What else seems weird about this? Is there another sense to me that seems weird as a hot chocolate that's actually double espresso? What about naming the chairman of his political party as the sole defendant? Is that weird? Or you guys are cool with that?
It sounds a little weird
Cool. I think
because
it sounds weird too. But
it feels like he didn't like it from a normal perspective. It would sound like he didn't know who to target for the issue.
yeah, it sounds weird. But I still think it arrives at the same answer of A, right? Because there's no case or controversy because you didn't name the right person.
Right.
Anyone disagree with A before we risk it all? Okay, there's no case or controversy here because the candidate lacks standing. One reason he lacks standing is that the issue is not right for review. It's not right because he will not suffer an injury until he is barred from running office or until he has won the election. Excellent point. At that point, injury will either have to occur or will be so certain to occur as to confer standing. The second reason the candidate lacks standing is that he has not joined the correct party to provide him the relief that will address the injury. The chairman of his local political party will be the correct party to sue if the political party refuses to put him on the ballot due to residency requirement. However, the candidate seems to be challenging the qualifications with the assumption that he will not be allowed to take office. The correct defendant would be whichever official enforces those qualifications and determines whether elected officials take office, presumably election officials. Finally, the mere agreement by the parties that the court should consider the issue as irrelevant. Standing cannot be created by agreement. B is incorrect. The qualifications of elected official, even for a local election, do not present a substantial federal constitutional question. C and D are incorrect. The court may not reach the merits of the case if the candidate lacks standing. Moreover, it is not clear that the resident requirement would deny candidates equal protection of the law. The federal courts may not modify the state law by finding substantial compliance, even if the state law is otherwise constitutional. Okay, excellent. Sorry, one more thing I have to do is our cram guide for February 2024. Amazing. And this is one of the most important things that we do as a course is we create our own cram guide. Question right or question wrong, we document it, and everyone should be doing this on their own. The purpose of my workshops on the weekend are 2 hours, maybe a little bit extra if I'm feeling caffeinated, for y'all to learn the best techniques of practice. For MBE, which we're doing today, this is the best technique. Do live questions on commercial Q bank after you've done our assignments, and get them right, get them wrong, document them so you have something to refer back to, because as great as you think your memory is, you won't remember everything. And if you write it down, you can refer back to it. So today we're going to do con law, and the date is the 7th. Is that correct?
Yes.
Yes.
I'm coming up 2 days from a very important anniversary for me, half anniversary. What's that called? A half anniversary? I learned a new word today. This is the last ADD moment of the class. It's called a microkini. And it's a word for bikinis that are so small that you can barely see them. Apparently that's a new fashion craze. All right, so what do we take away from this? To have standing, the case must be right. You cannot be considering to run for office and sue under a candidacy requirement statute. Furthermore, Susan, if you are suing for a candidacy requirement, you must sue the, who did they really say we should sue? The correct offender would be the election official, right? Election official, not your party's chairman, right? Something I do want to take note of for everyone is, I was saying earlier, does anyone remember the fundamental rights? Right to candidacy is a fundamental right, right?
I know it is in Florida. I don't think so, but I'm not sure.
It's a fundamental right, but they would apply rational basis to alienage requirements because it's part of the governmental process. Kind of like being a president, right? You have to be born in the USA. But for me to be a candidate, it would be a strict scrutiny analysis. Again, I know that's difficult. I was born in Miami, which doesn't feel like the USA, but it is. Okay, let's do another question. Oh, I'm still not on camera. I don't know why I think I still can hide the grays in my hair, in my beard. I didn't used to look like this. I think teaching the bar is getting the best of me. All right, let us do another question, another poll, and we'll keep it moving. I appreciate everyone's patience and getting to work and getting rolling today, but you know what they say, once you pop, the fun do not stop. All right, ooh, a super short one. A law imposes a tax on all leases of real estate. The tax is calculated on gross rent as imposed on the lessee at the beginning of each lease term. May the state collect this tax on the lease of the office space in the state by the United States Social Security Administration. No, because such a tax on lessees is not rationally related to legitimate. I'm sorry about all that. That seemed to be problematic. Oh, okay. It's another short one. Sorry. If anyone, let me rerun that poll back. Did anyone guess already? Yeah, 2 people guessed. No fault. Slippery fingers today. I'm sorry. Can everyone see the new poll? A state law provides that a person who has been divorced may not marry again unless he or she is current on all child support payments. A woman who has refused a marriage license pursuant to this law sue the appropriate state officials. Which standard should the court apply in reviewing the constitutionality of this law? The state must show that the. You don't see the poll?
No.
Me neither.
All right. That means it's not showable. Thank you for that. Okay. A state law provides that a person who has been divorced may not marry again unless he or she is current on all child support payments. A woman who has refused a marriage license pursuant to this law sued the appropriate state officials. What standard should the court apply in reviewing the constitutionality of this law? The state must show that the law is necessary to serve a compelling government interest. The state must show that the law is substantially related to an important government interest. The woman must show that the law serves no important public purpose. The woman must show that the legislator did not have a rational basis for enacting the law. Anyone need more time? Wow. A lot of agreement. So everyone's picking A, right? Why? Because this is M in camper, right? This is M. U.S. Supreme Court precedent establishes that an individual's decision to marry is a fundamental right. Therefore, laws that unduly burden the decision to marry trigger strict judicial scrutiny. This strict scrutiny standard obligates the state to prove that the law is necessary to serve a compelling government interest. Here, the law burdens the right to marry by requiring that a person who has been divorced may not remarry unless he or she is current on all child support payments. Because the law burdens the fundamental right to marry, the court will apply the strict scrutiny standard and require the state to prove that the law is necessary to serve a compelling state interest. So I think we can say that marriage is a fundamental right that triggers strict scrutiny. Camper. I'll put the A in lowercase. And remember, when I'm talking about these things, like I put the A in lowercase. That has nothing to do with my stance on things like that. I'm just teaching the facts. All right. Let us do another poll. Sorry. Got a lot to do. Stop sharing. Share results. Oh, you guys did amazing. Stop sharing. New poll. Who this? All right, we can see. Everything is perfect. Okay. Which of the following constitutional provisions would be the most helpful to the doctor in an action to challenge her exclusion from the Redville Hospital solely on the basis of the hospital rule? A doctor who resides in the city of Greenville in the state of Green is a physician licensed to practice in both Green and the neighboring state of Red. The doctor finds that the most convenient place to treat her patients who need hospital care is the publicly owned and operated Redville Municipal Hospital of the city of Redville in the state of Red, which is located just across the state line from Greenville. For many years, the doctor has successfully treated patients in that hospital. Earlier this year, she was notified that she could no longer treat patients in Redville Hospital because she was not a resident of Red, and the newly adopted rule of Redville Municipal Hospital, which was adopted in conformance with all required procedures, say that every physician who practices in that hospital must be a resident of Red. Which of the following constitutional provisions would be the most helpful to the doctor in an action to challenge her exclusion from the Redville Hospital solely on the basis of the hospital rule? Anyone need more time? Let's see what we got. I'm really proud of the participation. You guys are making me feel like this is fun. So when I look at the participation, we do have a heavy lean towards B. Does anyone feel comfortable explaining why B is the correct answer? I agree with B, so that helps you feel confident in explaining. All right, well, I'll kind of take the wheel then. I think it's B because this seems to be depriving out-of-staters of the privileges and immunities of residents of the state. The other one maybe would be due process of the 14th Amendment. That's a fine answer. Bill of Attainder is punishing people without trial. Ex post facto law is retroactively punishing people for behavior that was legal at the time. Due process clause, are they taking away due process rights? I think it's better answer privileges and immunities because it really does seem to be focusing on exactly what privileges and immunities is related to, which is out of state rights. You should be afforded the privileges and immunities of the people of the state. Anyone disagree with that analysis? Let's see. Nervous. Perfect. Under the Privileges and Immunities Clause of Article 4, a state may not impose residency or citizen requirements on non-residents without demonstrating a substantial interest justifying the classification. Here, there's no indication that the state has a substantial reason for requiring all physicians to be residents of Red, and thus would not likely satisfy this burden. An example of like a substantial reason would be like if they were trying to prevent people from like some tax harbor and people were just moving to the state for 30 days and moving out, then maybe it would be like in order to prevent this, they have a 45-day requirement to get the tax advantages XYZ, but they would have to really show that in the fact pattern. Here, it just seemed like they were hating on out-of-staters. So they may not impose residency or citizenship requirements on non-residents without demonstrating a substantial interest. Okay, let's put that on the guide. Okay, privileges, sorry for that error. Privileges and immunities clause of Article 4 requires that states cannot impose residency requirements on non-residents. There we go. On non-residents without establishing a substantial, what did they say? Without establishing a substantial interest justifying the classification. I like that. Interest justifying. Excellent. I cannot wait to have a computer and I can let my hands go on the keyboard. So in my keyboard is like my guitar, you know? All right, let's do another poll. Let me just stop sharing real quickly because there's some things going on in the chat and I want to make sure it's nothing too imperative. Okay, you all figured out how to poll things. Never count sheep in red lanes. Let me see if that makes sense to me, Daniela. So
it would start with strict scrutiny.
Oh, for strict scrutiny. Can you explain
Yeah.
that to the class?
Yeah, so it starts with strict scrutiny, then intermediate, and then rational. So never count would be narrowly tailored and compelling. Then never count, then red, no, what? Sheep? Oh, you confused me.
Substantially related to an important interest, and then
Yes.
rationally related to legitimate
Never
interest.
count sheep in red lanes. Yes.
I
There-
did not confuse you.
There you go.
All right, so I can explain that. NC is for strict scrutiny, and that needs to be narrowly tailored and a compelling interest. SI is for intermediate and needs to be substantially related to an important interest. And then RL is for rational basis and needs to be reasonably related to a legitimate state interest. All right, cool. All right, here you go. Someone told me I should write children's books for a living. So maybe me and you could put some stuff together, put our heads together. Anyway, let's do a new poll. New poll, who this? So far, so good. And I'll share my screen again. I can't figure it out. All right, we're back in business. Any preguntas so far? Ooh, short question is my favorite. Pursuant to an arrest warrant issued by a federal judge, FBI agents arrested a state governor for an alleged violation of federal law. The governor was then placed in a federal lockup facility. A state judge has issued a writ of habeas corpus against the director of the lockup facility on the ground that the federal law in question violates the 10th Amendment. Is the writ valid? No, because only federal courts can issue habeas writs for individuals in federal custody. No, because the arrest was made pursuant to a warrant. Yes, because state sovereignty shields the government from federal coercion. And yes, because the Constitution guarantees the availability of habeas corpus. We need this bird to be quiet, please. Does anyone need any more time?
Yes, please.
All right, let's see what we got. More polls. This iPad is also not good for my posture. All right, let's end the poll. Share the results. Most people are rocking with A for Andrew, A for awesome, A for absolutely, I agree, right? Because this is a state judge ordering a federal writ. That would be like a governor pardoning someone for a federal crime. That would be like a president pardoning someone for a state crime. It just seems to be like not within their domain. Does anyone disagree strongly with A? Yeah, disagreeing strongly with A would be unwise. A is correct. The Supremacy Clause prohibits states from issuing habeas writs that interfere with the federal detention. See Tarbell's case. Oh, good old Tarbell's case for 1871. Class agreed. When there's a conflict between state and federal law, the federal law will be supreme. Right? This is that example. Federal law is the principal, state law are the teachers. I think that's a pretty decent way of visualizing it. If not, sorry. We all agree. B is incorrect. The fact that the arrest was made pursuant to a warrant does not automatically make the arrest constitutional. Sure. The governor of a state does not enjoy federal immunity from prosecuting for violating federal laws while in office. The inability of state courts to issue habeas writs against federal detention is not unconstitutional as a violation of the suspension clause, because federal courts will be able to issue such writs. The suspension clause, where's Matt Beckerman when I need him? All right, so let's talk about the more simple matter that only federal courts can issue writs for individuals in federal custody. That sounds pretty simplistic to me. Only federal, what did they say? Only federal courts, right? Yeah. Only federal courts can issue habeas. For individuals in federal custody. If people are like, oh, that was an easy question, la di da. I mean, not everyone got it right, and it's not that easy of a question. Give yourself credit. You're dialed in, and I just want everyone to stay dialed in until the test, and then you could go off and undial. All right, let us do another question, another poll. I think we got a good groove going on. By the way, if anyone has any friends or family out there who are taking this test, you could still join the course and catch up, because I think that the course is going smoothly and I want to help people. So have them hit me up. Let us do another question. Is the poll good to go? You can see the poll? All right, good luck,
Yes.
Gabby. Ooh, another short question. See, Biscuit? Biscuit is short. We like short questions. On the basis of scientific studies showing a causal, I teach the LSAT for another living. I know I have a lot of livings, but on the LSAT, Lord, how many people confuse the word causal and casual. They are totally opposite, but be very dialed in when you're reading every single question. Every question is an island. Getting questions wrong because of reading comprehension mistakes is not acceptable on this exam, because the questions are too hard that you can't, handicap yourself. So this says causal, not casual. And I'm only zeroing in on that because I teach the LSAT, and that's a very classic misread. On the basis of scientific studies showing a causal relationship between the consumption of red meat, principally beef, and certain forms of cancer, a federal statute prohibits all commercial advertising of red meat products. The statute does not, however, restrict the sale of red meat products. Producers of red meat have challenged the statute as a violation of free speech rights protected by the First Amendment. Is the court likely to find the statute constitutional? No, because it does not serve a substantial government interest. No, because it's more extensive than necessary to serve the government interest in preventing certain cancers. Yes, because it does not affect speech protected by the First Amendment. Yes, because it serves a legitimate government interest in protecting public health. Does anyone need more time? Okay. Excelente. 73% participation. Sweet. Do you guys think it's gonna be the Bills or the Dolphins tonight? All right, nobody's awake. So most people pick B. I mean, you're awake, you guys are picking, but you're so dialed in, you're not even thinking about football. So B is in by far the best answer we could pick. I believe this is overreaching, right? Like, whoa, it's just not narrow enough. We're trying, I mean, it would be ideal if not ideal, but would be a fair thing to say that all red meat needs to include a warning that it could potentially cause cancer, much like cigarettes. They should have warning labels on white mochas at Starbucks that they have 2 shots of espresso in them. I mean, yeah, I think that warning labels could be a little bit narrow, but this right here seems overly extensive. Let's see if they agree. They do. Even though the government has a substantial interest in preventing cancer, for sure, and arguably advances that interest to prohibit all commercial advertising for meat products, it's not narrowly tailored to achieve that interest. So B is correct. The commercial speech at issue fails the test that applies to the restriction of commercial speech that is not misleading, fraudulent, or unlawful. First, it is true that the government has a substantial interest in preventing certain cancers. Second, it may be argued that preventing the advertising of red meat directly advances the interest in causing cancer by reducing the number of people who buy it based on advertising. However, prohibiting all commercial advertising for red meat is not narrowly tailored to achieve that interest. it really zeroes in on something I try to teach, and it's hard to teach because I can teach the law and I can have you recite it back to me and I know you got it. When I teach this, it's just I have to diagnose you in real speed. And that's why that's why my tutors and I really work hard with our students to see what they're thinking when they answer questions. Because what's wrong with this question right here? And you always want to see what's wrong with it. The federal statute prohibits all commercial advertising. That's a very broad word. You're looking for overly broad. You're looking for absolute, the only, all, they must. There's absolutely no other way. Things that just don't leave any room. We don't like that. All, how about all red meat that has been shown to have a link? I mean? There's like a lot of different ways that we could have narrowed this down. So a ban on all forms of commercial speech, even if serving a compelling interest, likely is not narrowly tailored. For example, a statute banning all advertising of red meat in response to a proven link between red meat and cancer is overly extensive. See, I feel like these caffeine shots have made me like overly attentive to like everything. I can't operate like this. I'm doing my best, Evan. I'm doing my best. Okay, ladies and gentlemen, let's do another poll. If you all like me overly caffeinated like this, I don't like myself like this mentally. But we're doing good as a class. I keep unstaring myself in the video. Why? Okay, this is a new poll, right? Can everyone see the poll? All right, cool. All right, we're doing amazing as a class. That's good. The owner of a local road paving company has for several years provided road repair and maintenance services for a small town under an annual contract. The owner's price is usually lower than the prices of other bidders because the owner's equipment and personnel are located in the town. So just real quickly, the call of the question is the mayor's selection of the other contractor constitutional? In a recent town mayoral election, the owner supported the candidate challenging the incumbent mayor. The owner's paving trucks carried bumper stickers promoting the challenger. When the incumbent mayor saw the owner in a local restaurant, the mayor said, "You'd better get those bumper stickers off your truck or you'll never pave another road in this town again." The owner simply refused to comply. I don't know why I said simply. The owner refused to comply. The incumbent mayor won the election. When the road construction projects for the next year were put out to a bid, the owner of the local paving company was again the lowest bidder. The mayor, however, vetoed the selection and chose a contractor from farther away at a much higher price. State law does not require selection of the lowest bidder. Is the mayor's selection of the other contractor constitutional? No, because the mayor's action in choosing a higher cost bidder over a lower cost bidder has no rational basis. No, because the mayor's action is a violation of the owner's right to freedom of expression and association. Yes, because state law does not require selection of the lowest bidder. No, because the mayor can require those who work for the town to support its current administration to ensure that the work is consistent with the administration's policies. Let me know if I need to scroll up or down for anyone or something. Does anyone need more time? I'm being bullied by my dog to stay outside, so let us stay. Okay, no more time is needed. Let's see how the people decided. We have a pretty even, not even, we have a good, well, I'll let you see what I see. Most people are picking with B. B is in basketball. I agree, they were tripping, right? Like, the mayor was saying, if you put those bumper stickers, you'll never pave another road in this town again. And then he clearly chose not to work with that guy based on his beliefs, right? Like, that's not cool. For the record, that is why I try to stay very politically independent and not piss off anyone when I work, because I'm a business person. And yeah, the mayor may lost this one, but in reality, this happens all the time. So just generally speaking, be careful with how you express yourself. Even though you may be constitutionally allowed to do it, you might piss people off. But it is here. This is bad because this is state action, and this is the mayor acting maliciously towards someone because of how they express themselves at the detriment of the town, right? Because, you know, the guy who was the lowest bidder and they picked him, but the mayor totally vetoed him because he didn't like him. I think that's not cool. And I don't mean to keep moving you away, Gabby. I had some feedback from students that the in camera was made a little bit hard to read.
No worries.
Yeah, it's not you. I feel bad. I keep swiping you away, but it would be anyone. It's not you.
Yeah.
I'm not like, get out of here, Gabby. I'm just like, yeah. All right, so let us see. Correct. The First Amendment rights of free expression and free association apply to government contractors in the same manner as they apply to government employees. Government officials are prohibited from penalizing employees and contractors because of their political beliefs or associations unless political beliefs or affiliations are relevant to job performance. Here, the contract is for road construction, which does not involve political policy making. So again, this kind of shows the difficulty of the MBE. Maybe you know the law, but you have to see it in the fact pattern, right? So that's why I like my cram guys, because I kind of boil it down to the same clown and the particular wig that this clown is wearing. If you're new to the class, my metaphor of same clown, different wig alludes to the idea that on the MBE, a lot of this, it's not so much memorizing the law, which you must do, of course, but it's also becoming familiar with the different patterns. And you see, okay, this hypothetical scenario that I'm familiar with is a lot like this one I'm encountering on test day. And I remember this is how the answer and explanation was for the original one. So this is likely what it will be for the one I'm encountering now. Same clown, different wig. That's Sam, one of my former students, and now working her way up the totem pole in Ibis Prep. She came up with that. So anywho, if a contractor has a bumper sticker that is political and the mayor discriminates against his company as a result, this is unconstitutional. It would only be constitutional if the speech of the, let's make sure that that is important. If a government contractor, right? This dude was a government contractor. If the government contractor speech clearly, I don't want to use that word clear, but the government contractor speech negatively impacted his ability to perform his job. Fair enough. Like, you can't just not pick this guy because of his bumper sticker. That is going to be a violation of freedom of expression. Why does my camera keep turning off? It's like God's sign I'm too ugly for camera today. I have a radio voice. That's what my dad used to always, that's like his favorite joke. Such a dad joke. You're like, I want to be an actor when I grow up. Like, you're more fit for radio. All right, so let's do a new poll. That's not a good poll. Let's not do that poll. Let's do a new poll. Thank you for your patience in my polling. All right, that's a good one. This is one of the greatest polls of all time. So let us return. What's up, Gabby? All right.
Nothing much. I had to use the restroom. That's
No,
why my
no.
computer was off.
You're good. You're good. Is the law constitutional? Let's check it out. PTSD. I think everyone has that after they take the bar exam, right? Is the law constitutional? A number of psychotherapists routinely send mailings to victims of car accidents, informing the victims of the possibility of developing PTSD as a result of the accidents and offering psychotherapy services. Although PTSD is a possible result of a car accident, it is not common. Many accident victims in a particular state who received the mailings complained that the mailings were disturbing and were an invasion of their privacy. These victims also reported that as a result of the mailings, the regard for psychotherapists and for psychotherapy as a form of treatment has diminished. In response, the state enacted a law prohibiting any licensed psychotherapist from sending mailings that raised the concern of PTSD to a car accident victim in the state until 30 days after the accident. The state justified the law as an effort to address the victim's complaints, as well as to protect the reputation of psychotherapy as a form of treatment. Is the law constitutional? No, because the law singles out one type of message for prohibition while allowing others. No, because the mailings provide information to consumers. Yes, because mailings suggest the possibility of developing PTSD as a result of an accident are misleading. Yes, because the law protects the privacy of accident victims and the public regard for psychotherapy without being substantially more restrictive than necessary. Does anyone need more time? Okay. Wow, everyone picked the same answer. Are you sure that the 8 other people don't want to pick it too? 8 other people sleep by the wheel? All right. Sleep is good. I have a student taking the LSAT this week, and I messaged her this weekend. Hope you're getting sleep and relaxing. We all picked D. D is very clearly the answer for anyone who lives in Florida because this is a law in Florida. You cannot send any mailings to victims of accidents for 30 days. It's usually targeted to the lawyers, the quote unquote, I didn't say this, but how they are called sometimes, ambulance chasers. So that it was getting a little bit malicious in terms of, you just got in an accident, you're trying to heal up, and now you're getting solicitations too many. So I think this is good. Sorry for the bird chirping. I tried to tell the bird to be quiet earlier, but he didn't listen. So D is correct. The law is constitutional because it satisfies the First Amendment standards for government restrictions on commercial speech. The mailings contain commercial speech because they advertise services provided by the psychotherapist. A restriction on commercial speech is subject to a form of intermediate judicial scrutiny, requiring the government to show that the restriction directly advances an important government interest and that the restriction is not substantially more extensive than necessary to protect that interest. Key point, we didn't mention that commercial speech is subject to intermediate scrutiny. The law here satisfies that standard. A 30-day waiting period nearly tears government's substantial interest in protecting both the privacy of accident victims and the public regard for psychotherapy. That's a key nuance that I'm going to add, that commercial speech is technically subject to intermediate scrutiny. Let's talk a little bit about commercial speech. Subject to intermediate scrutiny. So a 30-day prohibitionary period. Come on, man. Prohibitionary period is for mailing accident victims is usually upheld as what they said it had to be important and substantially related to important government interests. As substantially related to government interest. And then we have to also understand interest. We also have to understand that fraudulent or misleading commercial speech is not protected. So people, actually no one in this class, but people may have in the past or in another lifetime thought that this was fraudulent or misleading, but it really wasn't, because in my opinion, it said that it was a possibility, and they did say it is a possible result. So it's not false or misleading. It's just a little bit overwhelming. Let's do another poll. I don't know why. I guess my video stops every time I do a poll or something. I don't know. Or I'm really that ugly, really that radio voiced. Oh man. Can everyone see the poll?
Yes.
All right. So the Federal Family Film Enhancement Act, that's a tongue twister, alliteration. The Federal Family Film Enhancement Act assesses an excise tax of 10% on the price of admission to public movie theaters when they show films that contain actual or simulated scenes of human sexual intercourse. Ew, gross. Which of the following is the strongest argument against the constitutionality of this federal act? I'm just kidding. It's not gross. Sex is beautiful. It's all jokes. Just let me live. The act imposes a prior restraint on the freedom of speech protected by the First Amendment. The act is not rationally related to any legitimate national interest. The act violates the equal protection concepts embodied in the Due Process Clause of the Fifth Amendment because it imposes a tax on the price of admission to view certain films and not on the price of admission to view comparable live performances. The act imposes a tax solely on the basis of the content of speech without adequate justification, and therefore it is prohibited by the Freedom of Speech Clause of the First Amendment. Does anyone need more time? Let's see. Ooh, it's a lot of people picking the same answer. That's good. 71% participation. We like that. Most people are picking D, as in freedom of speech. Seems to be the issue here, right? They're really focused on the type of speech. See what some people may have picked. Yeah, no one else really picked. I mean, not no one else, but seems to be a high understanding that this is a freedom of speech issue. The federal government is regulating through this tax what kinds of things people can be shown. That regulation is based on content. Content-based restrictions must satisfy strict scrutiny, and there's no compelling government interest that this regulation was narrowly tailored to achieve. The act assesses a tax on the price of movie tickets when they show films that contain actual or simulated scenes of sexual intercourse. Obscenity is defined as a description or depiction of sexual acts that a reasonable person, applying contemporary community standards, would think appeals to the prurient interest in sex, portrays sex in an offensive way, does not have serious literary, artistic, political, or scientific value, all of those three. Here, the facts simply state that it contains actual or simulated scenes of human sexual intercourse. It does not rise to the level of obscenity and therefore is protected speech. Okay, so, excuse me, Bert, can you please be quiet? I'm trying to work here. Oh man, how do I do this? I'm so smart. I'm just kidding. So, what are we trying to talk about here? Oh yeah, a ban on movies showing sexual intercourse is a violation of First Amendment freedom of speech. We agree? And what we must take away from that is sex is art. Unless it's really not. You know what I mean by that? Like, it's got to be like, I'm just going to say sex is art. Let's just keep it beautiful here. Everyone go make some art today after class. Unless you're in a committed relationship, don't make art with someone else. Life lesson right there. Why does the camera keep coming off? You don't get to see it. I'm smiling when I'm saying these things. I bet they sound a lot more sinister on the radio. Okay, let's do a new poll. New poll. How about this poll? Perfect. Cruising right along. Oh, yikes. Which of the following, I didn't mean to do that. I'm sorry. I'm a big proponent of positivity, and every question is awesome. If you don't think that, go watch the Legos movie. Everything is awesome, including this question. A company owned a large tract of land. Let's see what the call to question is. What's the following most appropriate result of the action? Okay. A company owned a large tract of land that contained coal deposits that the company intended to mine. The company acquired mining equipment and began to plan its mining operations. Just as the company was about to begin mining, Congress enacted a statute that imposed a number of new environmental regulations and land reclamation requirements on all mining operations within the United States. The statute made the company's planned mining operations economically infeasible. As a result, the company sold the tract of land to a farmer. While the sale price allowed the company to recover its original investment in the land, it did not cover the additional cost of the mining equipment the company had purchased or the profits it expected to earn from its mining operations on the land. In action filed against the appropriate federal official, the company claims that the statute affected a taking of its property for which it's entitled to just compensation in the amount equal to the cost of mining equipment it purchased and the profits expected to earn from its mining operations on the land. Which of the following is the most appropriate result in this action? The company should prevail on its claims for the cost of the mining equipment and for lost profits. The company should prevail on its claim for the cost of the mining equipment, but not for lost profits. The company should prevail on its claim for lost profits, but not the cost of the mining equipment. The company should not prevail on its claim for the cost of the mining equipment or for lost profits. Take your time with this one. I've done this one before. This question is not easy. Does anyone need more time? Someone texted me from class that they're cracking up. I think it's about my art comment. I don't even know what I'm saying these days. The older I get, the crazier I get. No, not really, actually. I used to be a lot more funny, I think. I think I'm losing my humor as the world gets colder. All right, let's see what we got here. Pretty much a lot of people are rocking with D. What did D say? Yeah, I agree with D. They're not going to get any of this. Can anyone explain why they think D is the correct answer?
I think it has to do with, first, they were able to sell the property to the farmer, and they could still operate the mining, but in other places except for that particular land. So it's not like banning them completely from the practice of their original purpose of mining. It's just in that particular area. And the fact that they could still sell the equipment after they purchased it.
I agree with what you said. They could sell the equipment. They already sold the land. They didn't really suffer any damages here. Just kind of sucks. D is
Yeah,
correct. It did not constitute taking of the land or equipment because it did not deny all economically viable use of the land. The company was able to recoup its original investment and can still make economic use of the tract as farmland. The company should not prevail in any aspect of its claim for just compensation. It did not amount to a taking of the mining equipment because the new regulations did not deny all economically viable use of the land or equipment. They recovered its original investment by selling the land to the farmer, and the land is economically viable as farmland. The company may sell its mining equipment or use its mining for other land. Finally, the profits the company expected to earn from its mining do not constitute a property interest subject to the taking clause. I think the key takeaway from this one is lost profits do not constitute a taking, and you cannot recover for the price of equipment that you plan to use be resold. Lost profits do not constitute taking, and you cannot recover for the price of equipment that you plan to use because it can be resold. This assumes that there is still economic viability to the land. For example, mining land is sold to a farmer and the farmer can still farm. I mean, honestly, this point is kind of tough if you don't remember the question to really take from, but you see what I did there? Take from, taking. All right, anyway, let's stop all that and go to the next poll. To the next poll. That's going to be everyone in November. To the polls to vote between two octogenarians. I'm only 9 months away from being eligible to run for president. You guys are considering. Although my dad probably thinks I'm not handsome enough. All right, this seems like a long, boring question. No, I'm just messing with you. Me and my dad love each other. It's all good vibes in my family. He's super happy. He's a Michigan Wolverines fan. That's where he went to school, and they're playing for the championship. So let's hope they win. Washington winning would be cool too. Whatever. All right, this is a very long question, and I think it's gonna be too tough. Well, whatever. Let's fucking do it. Sorry if it's hard for y'all to read top and bottom. I'll do my best to scroll along. So in this case, who should the court rule for? A city ordinance requires a taxi cab operator's license to operate a taxi cab in that city. The ordinance states that the sole criteria for the issuance of such a license are driving ability and knowledge of the geography of the city. An applicant is tested by the city for these qualifications with a detailed questionnaire, written oral examinations, and a practical behind-the-wheel demonstration. The ordinance does not limit the number of licenses that may be issued. It does, however, allow any citizen to file an objection to the issuance of a particular license, but only on the ground that the applicant does not possess the required qualifications. City licensing officials are also also authorized by the ordinance to determine in their discretion whether to hold an evidentiary hearing on objection before issuing a license. A woman applies for a taxi cab operator's license and is found to be fully qualified after completing the usual licensing process. Her name is then posted as a prospective licensee, subject only to the objection process. A licensed taxi cab driver files an objection to the issuance of such a license to the woman solely on the ground that the grant of a license to the woman would impair the value of their licensed driver's existing license. The licensed driver demands a hearing before a license is issued to the woman so that he may have an opportunity to prove his claim. City licensing officials refuse to hold such a hearing and they issue a license to the woman. The licensed driver petitions for review of this action by city officials in an appropriate court, alleging that the Constitution requires city licensing officials to grant his request for a hearing before issuing a license to the woman. Just kind of let everyone soak that one in. Okay. In this case, the court should rule for the licensed driver because the due process clause of the 14th Amendment requires all persons whose property may be adversely affected by governmental action to be given an opportunity for a hearing before such action occurs. The licensed driver, because the determination of whether to hold a hearing may not constitutionally be left to the discretion of the same officials whose action is being challenged. The city officials, because a licensed driver had the benefit of the licensing ordinance and therefore may not now question actions taken under it. D, city officials, because a licensing ordinance does not give the licensed driver any property interest in being free of competition from additional licensees. I'm going to scroll up for a little bit and then scroll down for a little bit. Does anyone need more time? Don't be afraid if you need more time to say you need more time. Most people are rocking with D. D, as in Dolphins, over Bills. It's gonna be a good game. I'm going with D too, right? Like, come on, buddy. Just like anyone who's tutoring for the bar, I would have noticed at the hearing before they're allowed to tutor for the bar, because then they might be better than me. Like, it's not how it works. So a person may not be deprived of liberty of property without procedural due process. The city ordinance is the source of the property right alleged here, but the scope of that property right is limited. Taxi cab licenses do not include a right to be free of competition from additional licensees. Furthermore, the ordinance does not limit the number of licenses that may be issued and provides for a hearing only when the ground alleges a lack of qualifications. Therefore, the grant of a license to a woman does not deprive the licensed driver of any property right that require procedures to protect it. Moreover, there's no statutory right to a hearing because the only ground for a hearing is a lack of qualification, and the decision whether to grant a pre-termination hearing is up to the discretion of the city licensing officials. I think a better way of just putting this is a taxi cab driver does not have a due process right to be free from competition. I think Uber's taking them out. When I went to college, there was no such thing as Uber. You had to hail down taxis. It was the land before time. Okay. I'm off camera again. Y'all know the Land Before Time with Petrie?
Yes.
All right, good luck, Gabby. You're pretty young. I'm surprised you know Petrie, but he's a legend, I guess. Let's do another poll. What else was cool back in those times? That had to be like early 90s, because I was young when that came out.
Yeah, well, apparently I really liked that movie, The Land Before Time, when I was little, but I also grew up with my sister who's 2 years older.
True.
So she
That was me
probably
too.
must have seen those type of things.
I had 2 older brothers. Sorry, that's the wrong poll. You guys can't do that poll. That's why I grew up with a bunch of 80s stuff.
Yeah. Even I vaguely remember the movie, but according to my sister, I was obsessed with the movie because of how cute the dinosaurs looked.
Yeah, they were cute. It's a sad movie though, man. Okay, let us continue. Can everyone see the poll?
Yes.
All right, all right.
Yes.
Are the residents likely to prevail in their claim? An environmental organization's stated mission is to support environmental causes. The organization's membership is generally open to the public, but its bylaws permits officers to refuse to admit anyone to membership who does not adhere to the organization's mission statement. In a recent state administrative proceeding, the organization opposed plans to begin mining operations in the mountains surrounding a small town. Its opposition prevented the mine from being opened on schedule. In an effort to force the organization to withdraw its opposition, certain residents of the town attended a meeting of the organization and tried to become members, but the officers refused to admit them. The residents sued the organization, claiming that the refusal to admit them was discriminatory and violated a local ordinance that prohibits any organization from discriminating on the basis of an individual's political views. The organization responded that the ordinance is unconstitutional as applied to its membership decisions. Are the residents likely to prevail in their claim? No, because the membership policies of a private action are not state action. A private organization are not state action. No, because the organization's right to freedom of association allows it to refuse to admit potential members who do not adhere to its mission statement. Yes, because the actions of officers in refusing to admit the residents as members violates equal protection laws. Yes, because the ordinance serves a compelling interest of protecting the residents' free speech rights. Anyone need more time?
Yes, please.
Take your time.
Thank you.
All right, let's see what we got. Pretty split here. Pretty split here. Can someone explain why they eliminated A and chose B instead?
I think everyone's kind of nervous.
Yeah, everyone's like a long-tailed cat in a room full of rocking chairs. Okay, can anyone tell me why they picked B? What do you think, Gabby? Did you pick A or B?
I chose A, but my guess would be, like, if anyone chose B, this is my assumption, would be that it's literally stated in the facts that the bylaws permit its officers to admit anyone to refuse to admit anyone in a membership who does not adhere to the organization's mission statement. So I'm assuming if the facts are clearly stating that, it has to be true.
Right. It does seem to be involvement with state action here because it's open to the public and they're discriminating against people. And the law is applying to organizations. Where's the law say? Of ordinance that prohibits any organization from discriminating on the basis of individuals' political views. So, you know, that is applying to them.
Yeah.
I think B is a better answer than A. Let's see how they explain it, or if we're right. Yeah, A is incorrect. Despite the fact that membership policies themselves are not state action, the local ordinance cited by the residents is state action and therefore subject to the requirements of the First Amendment. So their membership group is not subject to it, but the ordinance that they're challenging is a state ordinance. So that is what's at issue here. It's not whether their policies are wrong or right, it's whether they're forced to adhere to this policy or not. And because that policy is state action, A wouldn't be the correct answer. That's a tough question. I could see why a lot of people would have picked A. B is correct. The state may not force the inclusion of the residents because this would significantly burden the environmental organization's right of expressive association, given that one of its sincerely held purposes is environmental protection, specifically opposing the mine. If the residents were included, their aim to stop the organization's efforts would interfere with its free expression. So this is statutory Boy Scouts versus, I almost said Dale, but I'm sure it's Dale. I don't think they live in Miami. Let's read this extended explanation because this one's tough. The right to join together with other persons for expressive or political activity is protected by the First Amendment. This right is not absolute, however, and the state may infringe upon the freedom of association in order to serve a compelling government interest that is unrelated to the expression of ideas. Nevertheless, the U.S. Supreme Court has held that the state may not force a private club to include certain members when such forced inclusion would significantly burden the right of expressive association by the club, where one of its sincerely held purposes is in contrast to the views of the person attempting to be included. B is correct. The residents are not likely to prevail on their claim because it would violate the environmental organization's First Amendment right to freedom of association if the state would have forced the organization to accept the residents as members. The U.S. Supreme Court has held that forced inclusion of an unwanted person in a group violates the group's freedom of association if including that person would significantly affect the group's ability to express its viewpoints. The freedom of expressive association entitles the environmental organization to refuse membership to its residents because admitting them would inhibit the organization's expression regarding the mining operations. So that's a tough one. And again, when Matt was here on Thursday, I was trying to kind of drive that point home that a lot of these answers stem from specific case law. I'm sure Matt has read that Boy Scout case 7 times last week alone. Okay, so I'm not trying to make fun of Matt. I love Matt. I'm just being humorous. Okay, so the takeaway here is member organizations and groups may deny membership rights to people if allowing that person membership would significantly impair the stated purpose of the group. Refer to the Boy Scout case. Versus Dale. Versus Dale case. the reason I say refer to Boy Scout versus Dale case is because if that bothers you and you can't accept that at face value, honestly, the best thing to do is what Matt does and what true constitutional wizards do is read the case, and then you'll really understand how they arrived at that decision, what they were really talking about, what the views were, etc. But it's just kind of like if we have an organization and our stated purpose is environmental protection, and now this dude who's the wicked witch of pollution wants to come join the group, it's like, bro, you're not really good alignment with what we got going on here. All right, let's do some more. Oh, I'm not on video. Super weird.
Although I'm a little bit confused though, because like, what's the difference between that and choice A? Because I know like
Choice A, because choice A was absolutely incorrect because it said specifically that that organization is private and therefore not subjected to the Constitution. But that's a wrong answer because the question was asking about whether the ordinance can be applied to them. And looking at the ordinance, that clearly implicates state action. So A is right in the sense that they're a private organization, but it's wrong in the sense that there's no state action to implicate the Constitution.
okay.
All right, let's do a new poll. Stop sharing. I think I lost a soldier from the class. It's all good. All right. Everyone can see the poll? Some
Yes.
classes I have students read today, I'm so wired that I'm reading. Okay, which of the following best states the burden of persuasion? Remember, I talked about this at the beginning of class. It has to be correct. It has to be accurate and correct. A local high school has had a very high rate of pregnancy amongst its students. In order to help students who keep their babies to complete high school, the local high school has established an infant daycare center for children of its students and also offers classes in childcare. Because the childcare classes are always overcrowded, the school limits its admission to those classes solely to the high school students who are mothers of babies in the infant daycare center. A student at the high school has legal custody of his infant son. The school provides care for his son at his infant daycare center, but will not allow him to enroll in the childcare classes. He brings a suit against the school challenging on constitutional grounds his exclusion from childcare classes. Which of the following best states the burden of persuasion in this case? The student must demonstrate that the admission requirement is not rationally related to a legitimate government interest. The student must demonstrate that the admission requirement is not narrowly drawn as possible to achieve a substantial government interest. The school must demonstrate that the admission policy is the least restrictive means by which to achieve a compelling government interest. The school must demonstrate that the admissions policy is substantially related to an important government interest. Does anyone need more time? D is the strongest answer here. I know it seems crazy, but men can be discriminated against too, right? And that's gender discrimination. We often think about gender discrimination as discriminating against women, which admittedly it is most of the time, but gender discrimination could also be against men, and this would be a good example of that. Because only mothers, but this guy's a father. So intermediate scrutiny, important, substantially related. That's the SI from Daniela's amazing mnemonic. D is correct. The school's policy classifies on the basis of gender, a quasi-suspect class, and thus subject to intermediate scrutiny. This means that the government and not the individual bears the burden of persuasion in showing that the policy is substantially related to an important government interest. Okay? Targeted discrimination against men, fathers, subject to intermediate scrutiny. All right,
Andrew, I have a question on this one.
go ahead.
So I picked rational basis, because I thought, oh, it's gender, but it's also like, a parenthood status. I guess if there's like a suspect classification in any question, but it's paired with something like, a different classification that's not involved, is the suspect classification what is like defining?
So I want to just help you understand on this particular question, they weren't discriminating against parents. They were discriminating against gendered parents, mothers, only mothers. So that implies, and him, they was denied on the basis because he wasn't a mother. The reason that he's not a mother is because he's a father. And this is a very complex issue in 2024 for sure, but it is gender, whether mother connotates female, and him being excluded for not being a mother can only be reasonably understood to be gender-based discrimination. So looking at this as discriminating against parenthood status as a father, yes, but it's really in comparison to parenthood status as a mother, and comparing them on a horizontal level, it actually is a gender comparison. It may be difficult in the new age with more advanced understanding of gender studies, but that's the connotation here, and we got to take it at face value that if it's discriminating against parents who are not mothers, it's a gender-based discrimination.
Yeah. Okay.
No worries, man. All right, let's do, I'm not sure how many we did. We'll take like 10, 15 more minutes and see what we get to. Let's talk about, I said, let's talk about, you know what I was going to say, ART. Let's talk about art, baby. All right, new poll. Let's see how this one's looking. Not that poll. Perfect. Let's talk about art, baby. So, am I alive yet? All right, let's talk about fish and water. A mineral is added to bodies of fresh water to prevent the spread of certain freshwater parasites. The presence of those parasites threatens the health of organisms living in rivers and streams throughout the country and imperils the freshwater commercial fishing industry. The mineral is currently mined only in one particular state. In order to raise needed revenue, Congress recently enacted a statute providing for the imposition of a $100 tax on each ton of the mineral that is mined in the United States. Because it will raise the cost of the mineral, the tax is likely to reduce the amount of the mineral that is added to freshwater rivers and streams, and therefore is likely to have an adverse effect on the interstate freshwater commercial fishing industry. The mineral producers in the state have filed a lawsuit in federal court challenging this tax solely on constitutional grounds. Is the tax constitutional? No, because only producers in the state will pay the tax, and therefore is not uniform among the states and denies mineral producers the equal protection of the laws. No, because it's likely to have an adverse effect on the freshwater commercial fishing industry, and Congress has a responsibility on the clause to protect, foster, and advance such interstate industries. Yes, because a tax is necessary and proper means of exercising federal authority over the navigable waters of the United States. Yes, because the power of Congress to impose taxes is plenary. This tax does not contain any provisions extraneous to tax needs or purposes, and is not barred by any prohibitory language in the Constitution. Does anyone need more time? Okay. D looks like the strongest answer that people are picking. It's a plenary tax. It's not contains any. It's not barred by any prohibitory language. I like D. Does anyone have any thoughts about A versus D? Anyone super confident with D? And can tell me why?
Because under the 16th Amendment, Congress has the right to tax, that plenary taxing power.
Mm-hmm.
And it said that they need the money somewhere in there, I believe.
Yeah. We don't like necessary and proper, so that's why we eliminate C. It seems like they could do it, and D would be their best reasoning under the taxing and spending clause. A, equal protection, and then B, I don't love. Anyone gonna save me from picking the wrong answer if I go with D? Anyone feel strongly that D is incorrect? I feel like a long-tailed cat in a room full of rocking chairs. All right, thank you, class. You helped me on that one. I was a little bit concerned that it was only affecting that one state, but as I've said many times, they do have a plenary taxing power, and we shouldn't fight that. Thank you. D is correct. Congress's power to tax is plenary, and the tax measure will be upheld if it bears any reasonable relationship to the goal of revenue generation. This statute does not contain certain provisions extraneous to tax purposes, and it does not violate any other section of the Constitution. A is incorrect. Mineral producers are not suspect or quasi-suspect as a class, which means under rational basis review, the tax would have to be arbitrary or rational, which it does not. It's also uniform in its application. It just happens that the minerals only mined in a single state where anyone can come mine to it. Excellent. So again, the necessary and proper answer is very unlikely as a sole power. We want to use taxing and spending, or potentially commerce clause. I might have been looking for commerce clause, but to be fair, this was a taxing and spending measure. So the extended explanation, Article 1, Section 8, they have the power and a good MBE tip. Absent a specific restriction, be very hesitant to rule against a tax measure on the MBE. A tax measure will be upheld if it bears some reasonable relationship to revenue production, or if Congress has the power to regulate the tax activity. So let's add that. Let's just say that. Be very hesitant to rule against a tax measure, even if the effect of a tax only applies to one state, but the purpose is rational, then the measure is valid under Congress's plenary taxing power. Excellent. I don't know why I got nervous on that question, but you saw I was nervous. Good job, Pastor. All right, let's do a couple more. Oh, you didn't get to see how nervous I was because my camera just keeps coming off. But now I'm back. That's an old saying in the South, by the way, about the long-tailed cat. I don't know why I find it so humorous. Oh, no. Do not answer that question. Do not answer that question. I've learned my lesson. You guys like to hurt my feelings if given the opportunity. All right, let's do this one. All right. A state law to promote tourism creates an easement across a portion of a private farm for hikers who wish to use a historic trail that crosses the farm. The law allows the farm owner to charge hikers a fee to cover the cost of this use, but does not otherwise compensate the owner. Is the law constitutional? No, because the fee provision violates the Privileges and Immunities Clause. No, because the law takes the owner's property without just compensation. No, because the fee provides the owners with just compensation. Yes, because the law has the public purpose of promoting tourism. Does anyone need more time? See, most people are picking B. Let's see if I agree with B. Yeah, this seems like a taking, right? You're just gonna put a trail across my property, and just because we can collect the fee, like, man, that fee would have to be astronomical to justify what you are doing. Like, I don't want some random people walking across my farm. Oh no, the algae rhythm. That's not good. That's what happens when a lot of people are taking this exam. All right, I think it's a sign, and it's starting to rain a tiny bit. We'll do one more question, and we'll call it a day. But let's take away the most important piece here. The privilege and immunity. Oh, no, the state-created easement provides for the physical occupation of a portion of the owner's farm, and thus constitutes a governmental taking of that portion of land. The takings clause of the Fifth Amendment requires that the government provide just compensation to owners for the land it takes. Just compensation is determined by the fair market value of the taken land. Although the state allows the owner to charge a fee to recover costs from hikers who use the trail on the farm, it's not equivalent to the fair market value of an easement across the land. Therefore, the state law is unconstitutional. So the state cannot put a bridge over your farm without just compensation, and allowing you to charge a fee is not equivalent and just. Therefore, a taking has occurred. All right, and let's do one last question, and then we'll go over the ones that we've gotten wrong, which might just be this question, unless we could end on a high note. But either way, we always end on a correct answer. So if we get it wrong, we're gonna have to do one more. All right. Let's see if this poll works. Excellent. Nice, sure. Which of any of the following methods of appointing the commission members would be constitutional? A new federal statute establishes a 5-member commission on cultural heritage sites. The statute directs the commission to develop regulations to protect such sites on federal public lands and to implement the regulations through specified fact-finding and adjudicatory functions. The commission is not under the supervision or control of any federal agency. Which of any of the following methods of appointing the commission members would be constitutional? Members are appointed by a specially designated panel of federal judges. Members are appointed by the Speaker of the House of Representatives with the advice and consent of both houses of Congress. Members are appointed by the President with the advice and consent of the Senate. None of these appointment methods would be constitutional. Does anyone need more time? Right, let's see how we deal with the last question. It's looking like we are mostly picking C, as in cat. I agree. This seems to be an executive function, and we will want the advice and consent of the Senate. So let's see if that's correct. And I ask y'all to just stick around for 1 minute after this so I can share one with you. C is correct. The commission exercises significant legal authority, namely the authority to adopt and enforce regulations. For that reason, the commissioners are officers of the United States. They are not under any other federal agency, so they're not considered inferior officers and must therefore, pursuant to the appointments clause, be appointed by the president with the advice and consent of the Senate. So we're going to say they're superior officers. So superior officers are appointed by the president with the advice and consent of the Senate. Excellent. So you see, we did a pretty nice job. We're working through our cram guides. I have cram guides I've done from previous courses. You should be working on your own cram guides. But overall, very smooth day. I know that there was one question where I was a little bit hesitant on, but like I asked my class, y'all saved me, and we got what looks to be everyone correct. Let's check it out. All right, we got to do 15 questions today. That's excellent. And we were able to get them all right. So if you just stick around for 1 minute, I do want to introduce someone to you all who might be of service. Come here, my friend. This right here is Tariq. He's a personal trainer in Miami. Why don't you just take, 45 seconds to tell me a little bit about what you can do and how you can help.
Hello, guys. My name's Tariq. I'm a personal trainer. I now go by a longevity coach, but basically what I do is personal training. I also do stretch therapy for people that have any types of injuries like back pain, hip pain, or if you feel like your body's just not working the way that it should be. But yeah, I'm in Miami. I'm very mobile, so I travel to clients as well as have clients that come to me. But I think I'm a genius in my field. Andrew obviously wouldn't rep me any other way. But yeah, if any of you guys are looking to get into shape in the new year, or functionally have your body working correctly, I'm your guy.
Thank you, man. So he's coming here to make sure I get to the gym and stay healthy, and I really believe that health is wealth, sound body, sound mind. So I'm gonna have Tariq leave his information in the chat. If anyone wants to reach out to him, he'll come to you and he'll massage, stretch, and help you out with personal training. But everyone, thank you so much for joining me today.